Okay. So, rule of perpetuities, if you could just, like I said, this is a 100 level course.
Yeah.
So I'm just starting out. I have a basic understanding of a lot of different other kinds of trust, constructive trust. What really interests me was the spendthrift trust, which was really interesting. I have a friend of mine. She has problems, and I talked to her mother, and I said, look, go talk to you, find you a good attorney, and set you up a spendthrift trust with her because she is terrible with money.
Yeah.
But I do have a problem understanding the rule of perpetuity. So if you could just walk through that very easy, step by step, just the best way you can convey it to me. All
right. And this was probably, I don't know, 30 years ago when I studied the rule against perpetuities. But the rule against perpetuity says that a trust cannot last longer than 21 years plus a life in being at the time the trust was created. And if it violates that rule, then it's void from the beginning.
Okay.
So that's the simple part. The difficult part is determining the life in being. And that's why you go to law school.
Okay. All right.
So.
Right, okay, so you've got basically 21 years. So if I were to set up a trust, let's just say I want to set up a trust for my grandson, okay?
Right.
He has to already have been born. It's basically how the trust works, right?
Well, it's that the trust has to terminate in 21 years plus a life in being at the time. So the trust could actually extend for much longer than 21 years, but it's two components: the life and being at the time the trust was created, plus 21 years.
Okay, life and being. Could you explain that? Explain how what exactly is that? Does that mean? Does that mean the beginning of that person's life? That they have to be alive when the trust.
Someone who's alive at the time that the
trust is created.
That's correct.
Okay.
Yeah.
Okay, and basically what this does is it's basically so people don't monopolize a particular piece of property forever.
That's right. Perpetuity, you don't want that asset tied up in trust forever. So
okay.
It says at some point the trust has to terminate and the property has to be distributed outside the trust.
So would it then go to the remainder man, or would it go back to the grantor settlor?
Well, it depends. I mean, if you violate the rule against perpetuities, then the trust is void from the beginning. Whatever status, if it's real estate, for example, whatever the status of the title was at the time it was attempted to be conveyed into this trust, that's where it would be. Now that person, is likely dead. So you would have to look at what the status of title was at the time that this void trust was created, and when the real estate was attempted to be conveyed in there.
Okay. So let's just say the trust became void.
Yeah.
What would be the next step? What would be the situation awareness under that?
Well, you would just go back and trace the title to whoever owned the property at the time that they attempted to convey it into the trust.
And they pass away, and so would it go by will, or would it then go by intestate?
They have a will. It could go by the will.
Okay.
If they didn't, then it would go by intestate succession.
Okay. So that's pretty good. That's kind of what I was looking for. Basic fundamentals. The book that we're using is a digital book, and it's not very user friendly. I find sometimes that it kind of contradicts itself sometimes. Like it'll say one thing and then it'll say another thing, and it gets confusing. One other thing, and like I said, just 5 minutes, wrap it up. Do you have an example of a trust? I have to type out a trust, okay? And I've never done a trust. I've done wills. But I didn't know if maybe, is there a template somewhere so that I could go look at or download and pull it down? Or would you have an example of that?
Actually, I couldn't give you one of my trusts because that would be disclosing, confidence.
Proprietary information?
Of the client. Well, not proprietary, but confidences and secrets of the client. So we can't disclose that without the client's permission. what you can do, though, is that often trusts are recorded in the county records, especially if they're trying to deal with real estate. Mm-hmm. So you could go down to the county clerk's office in Burnett and look through the index until you find one that's been recorded, and then you can just print that out or see if you can just get the trust or the clerk's office to make you a copy.
Well, they have a couple of examples in the book,
yeah.
and they have a couple of different examples. And I looked at, there's like 3 examples. I looked at all 3. I'm not exactly sure which one I want to go with. I want to go with the simplest one first, and somewhat they're kind of confusing. I don't want to take my computer out and go through the whole process of showing you the book, but that's why I was just like, is there like a website that maybe somewheres where they just, besides the courthouse, that just says, here's an example, and they put print void across it, or something like that. Maybe like a pick dump website, or get like Getty Images or something like that.
I don't know about that, but if you just search for form of
is there a long form or a short form?
Living trust. Well, I mean, there are lots of different types of trusts, so you know, you just have to.
How long are they usually, like, let's just say a basic trust? Would it be what? Because I've seen a bunch of them out there.
Yeah.
Is a basic trust just something that's 1 or 2 pages, or is a basic trust just something that's 6 or 8 pages?
Well, you can find trusts that are shorter, but you know, in the age of computers, all documents have gotten longer. I remember when I was just a young lawyer, I came to practice here in Burnett County, and the senior judge in our court he'd been a lawyer for a long time at that point, but he'd also been in the Texas legislature, and you know, everybody knew him. He was a cool guy. Mm-hmm. But he said when he first started practicing law that he had to write a circuit to go to various places to have enough clients to represent and make a living. And he said he had a horse, and on this side he had the typewriter, and on the other side of the saddlebag he had the law book, and
that's how he did it.
All the laws were in the one book. And you know, back then when I first started practicing, we had divorce decrees, for example, that might be a couple pages, and now they run into, you know, 60, 80 pages.
Wow.
Just for, you know, like normal divorces. So you know, the computers have just made it so easy to put so much information in.
Yeah.
And with printers, you know, you make a mistake and you just print it out again, as opposed to having someone copy all that stuff out.
Let me ask you this, because I'm getting to a point to where I'm going to have to like start making decisions what kind of law I want to practice.
Yeah.
Like family law, I like criminal law.
Mm-hmm.
I have a friend of mine who is in personal injury and makes money hand over fist. Yeah. And I don't really, you know, and I'm not trying to get into personals, but as far as do you incorporate estate law in family law, or you just do estate law?
Well, I do both of those. I do estate planning and probate, family law, and I do bankruptcy as well.
Really?
So, you know, the thing about going to law school is that you are licensed to practice law in Texas, and you know, there are lots of different types of law you can practice, and really you go out and you find those areas of law that you enjoy and that you can make money doing. And a lot of lawyers I know, they start out in one area and they kind of change.
That's what I think about
as they go through. I would say that if you could work for a lawyer who does general practice, including civil and criminal, so you could get some experience in all sorts of law, that would be a good starting point, because that way you would be exposed to all different kinds of law, and you could say, well, I don't really like that bankruptcy stuff so much, but you know, I really like this criminal law practice. Mm-hmm. You know, it's just, and it's hard to say, because in law school, you're learning a lot about theory, but you don't know a whole lot about practice. Mm-hmm. And So the things that perhaps looked interesting in law school, maybe they're not so interesting when you actually practice in that area.
Yeah.
So, or vice versa, you know,
Yeah.
something that you thought was dull and boring, you get down into the practice of law and you find, well, that's a lot more interesting than I thought. So, you know, it's really, yeah, there's so many different types of law that you can practice.
Seems like it's very, very multifaceted.
I think that's right. Yeah, I think that's right. And you know, there are so many areas that I never practiced. I didn't do much criminal law at all. I never did patent. I never did tax. You know, there's so much stuff.
Maritime.
Exactly.
Yeah.
I didn't even study maritime. We didn't have a course in that. So, you know, there's lots of stuff out there, and I think that best idea is just find a place, either hang out your shingle and do all kinds of law, which is hard, it's difficult, or find somebody that practices like that and go to work for them.
How long have you been doing your own practice now?
Since 1990.
Really?
Yeah.
Wow. Okay, I'm impressed.
Yeah.
That's
27 years.
yeah.
So.
Well, thank you for your time, sir.
Okay.
I appreciate it.
Good luck.
Brandon Bauer, LS 225, concluding interview.